Opposition leader Alan Chasney had accused the SLP administration of an attempt at opacity with the proposed Public Finance Management Amendment. In a press interview prior to the House sitting, the Micoud South MP railed against the 2022 bill as adverse to good governance.
So the amendments that are being proposed today significantly water down the accountability.
Chasney took his grievance to the House floor in the August parliamentary chamber.
That if we give ourselves the opportunity for extending, and let's face it, so they're saying that they're going to be able to extend the presentation of the estimates, the laying of the estimates, until the end of April, which means then you have another 30 days after that for the appropriations bill. And the same thing that we have done for many years, in which we find ourselves more often than not approving a budget in the beginning of a new fiscal year. And that doesn't work. All the documents speak to that, Mr. Speaker, as a core element of our PFM. And I'm appealing to the government not to make this mistake.
But was it the opposition leader who is mistaken? According to Section 79 of the Constitution, quote, "The minister responsible for finance shall cause to be prepared and laid before the House before or not later than 30 days after the commencement of each financial year, estimates of the revenues and expenditure of Saint Lucia for that financial year." The fiscal year ends in March, back in 2020. Then Prime Minister Alan Chasney decided to amend the Finance Management Act to advance the date of the estimates, with the budgetary process beginning in February instead of the March-April timeline. Now in 2022, the succeeding SLP administration points out Chasney's 2020 Act appears to be at odds with the Constitution.
The law says you must deliver the estimates 1 month before the end of the financial year, which means it must be tabled in this Parliament before the end of February. Very simple to this. If you don't do that, you are in violation of the law. You are in breach of the law if you don't do this. You are required, it says shall, you are required to do it before the end of February. That's what it says. The Constitution, however, which is the supreme law, says you should do so before, which can mean January, February, March, but no more than 30 days after the end of the financial year, which means no later than the end of April. But you can do it before. You can do it in January, you can do it in February, you can do it in March, you can even do it in April. The Constitution, that is the supreme law of the land, says you can go up to the end of April. The Finance Act, which was passed, says you cannot go beyond the end of February. Is there not a conflict?
The government lawmakers claim there was no nefarious motive behind the latest SLP-led amendment, which simply sought to correct the law. Former Prime Minister Dr. Kenny Anthony recalled that the Alan Chasney-led regime rebuffed his initial advice back in 2020.
Once the Constitution speaks to the particular subject or the particular matter, to the particular field, there is no need to enact statutes. And that, I think, was the point at the time. And yes, I do remember, Mr. Speaker, the member for Swazelle looking at me most intently on that day. And he was agreeing with me, nodding occasionally, when the member for Micoud South was not looking at him. I remember. Do you remember that?
But the incumbent Gov'T South MP advised on Tuesday that given the supremacy of the Constitution, a simple repeal of the previous amendments would have sufficed in this case.
My position, Mr. Speaker, and I repeat, is if your Constitution has a provision, don't interfere. But the problem is, once the former government had decided to enact a provision that touched Section 79, that seek to give Section 79 a certain kind of meaning, a certain kind of flavor, as ordinary statute, then this government, its successor government, has a responsibility to correct what was in the previous legislation by repudiating it. That's the reality. And left to me, Mr. Speaker, all I would have simply have done was to introduce the legislation, repudiate the previous section that was enacted by the former government, delete it, expune it from the legislation. I wouldn't even bother enact clause 3, subclause 1, because consistent with what I believe the Constitution already speaks.
The ex-Prime Minister also recommended that the language in the newly amended Act of 2022 passed by the Labour administration reflect the words in the Constitution regarding the 30-day time frame to avoid any ambiguity. Joachim Duplessis, HTS News Force.